Dictation start. The present appeal has been filed by the defendant Haryana Urban Development Authority bracket start for short Hooda bracket close against the concurrent judgments and decrees passed by both the courts below, whereby the suit filed by the plaintiffs was decreed and the resumption order dated 8/3/2001 and the subsequent orders were set aside full stop. The parties herein would be referred to as the plaintiffs and the defendants as they were described in the original suit full stop para. The brief facts of this case are that the plaintiffs filed the suit for declaration to the effect that the defendant Hooda was entitled to charge interest only at the rate 10% simple interest and not at the rate 18% compound interest on the overdue amount, and further for declaration that the action initiated by defendant Hooda under section 17 of the Haryana Urban Development Authority Act, 1977, for short the Hooda Act, including the resumption order dated 8/3/2001, the appellate order dated 13/8/2002, and the subsequent actions are illegal, null and void, being beyond the power vested in defendant number 2, that is a state officer, Hooda, under the Hooda Act and the regulation framed thereunder full stop. Further, as a consequential relief, a permanent injunction restraining defendants from forcibly evicting the plaintiffs from the site in question was also prayed full stop para. It was pleaded in the suit that plaintiffs had purchased SCF number 85, Sector 8, Panchkula in an open auction held on 29/12/1988 full stop. The bid amount was rupees 8,02,500 as per the terms of the allotment, the plaintiffs had deposited 10% of the total consideration on the spot full stop. Thereafter, as per the conditions of allotment letter, an amount of rupees 1,20,375 was deposited with the defendants to make up the 25% of the price of the plot full stop. The balance amount of rupees 6,01,875 was to be deposited in half yearly installments full stop. As per the letter of allotment, each installment was recoverable along with interest on the balance price at the rate 10% simple interest full stop. It was further pleaded that due to some unavoidable circumstances, the installments could not be paid by the plaintiffs as per the schedule and the payment was delayed full stop. However, there was no condition in the allotment letter regarding charging interest on delay payment, much less any condition for charging 18% compound interest full stop. However, due to delay in payment of the installment, the estate officer, Hooda, Panchkula, the defendant number 2, proceeded to take action under section 17 subclause 1 of the Hooda Act full stop. Accordingly, notice dated 26/3/1991 was issued by defendant number 2, wherein an amount of rupees 4,71,785 was shown to be outstanding against the plaintiffs full stop. In this letter, it was further mentioned that an amount at the rate 10% of total amount, that is rupees 47,179 shall be charged as penalty in case the said amount was not paid forthwith full stop. It was averred that while arriving at this amount, defendant number 2 had calculated the amount by including the interest charged at the rate 18% compound interest full stop. Thereafter, defendant number 2 issued another notice dated 12/11/1991 under section 17 subclause 2 of the Hooda Act, where the amount of rupees 6,18,811.32 was claimed to be due full stop. Still further, another notice was given to the plaintiffs on 14/2/1992, again under section 17 subclause 2 of the Hooda Act, wherein the amount of rupees 7,32,246.42 was shown to be outstanding full stop.